releasing control as we're talking about control over our bodies. So thank you so much, Angela, for inviting me to be a part of this important symposium and conversation about Black hair, about big law. And I would say that even though this is the title of the presentation, Civil Rights, Law, and Lawyering, what's hair got to do with it, I think a sub-theme really is about how American law has not been compatible with and to Black hair and African descendants' experiences. And our human right, frankly, to express our cultural and our racial and our religious identities, among others. So we'll go to the next slide here. African descendants hair texture, I'm sure as you probably have already gathered throughout this conversation, has been and continues to be a source of pride, joy, inspiration, resistance, religious expression, alongside cultural and creative expression. Though often not discussed or simply just unknown, combating the denial of our most basic human rights on the basis of our natural hair texture and hairstyles, like similarly battling discrimination on the basis of our skin complexion, is deeply embedded in African descendants' liberation struggle since our ancestors' forced migration to unknown parts of the world to serve as enslaved laborers. Like our skin complexion and other characteristics signifying our African ancestry. We can go to the next slide. Like our skin complexion and other characteristics signifying our African ancestry, African descendants' natural hair textures and hairstyles like afros, braids, locks, twists, and Bantu knots have served as a source of racial enslavement, apartheid, exclusion, and stigmatization for nearly four centuries. Indeed, early American jurists declared a woolly hair texture or a hair texture that was inclined to be woolly signified African ancestry or Blackness, and an individual straight hair texture signified one's European ancestry or whiteness. Therefore, according to American jurists, a person could be consigned to enslavement solely on the basis of their woolly hair texture, independent of their skin complexion, and the straightness of one's hair could legally render a person free, or at least the presumption, legal presumption of freedom. So for nearly 4 centuries, like our skin color, African descendants' hairstyles resulting from our curly or coily hair texture have served as not only a marker of our racial identity, but also in turn, a vehicle to deprive us of our basic human right to be free from bondage, exclusion, and segregation, and other forms of undignified treatment on the basis of race. And we can go to the next slide here. Actually, the next slide. At the height of the 20th century civil rights movement, Congress passed several pieces of legislation like the Voting Rights Act of 1965 and the Civil Rights Act of 1964 to address longstanding racial exclusion, subordination, and segregation spheres like employment, housing, voting, education, and public accommodations. With Title VII of the 1964 Civil Rights Act in particular, Congress sought to remove arbitrary barriers to Black Americans' equal access to employment opportunities and their corresponding economic security and enjoyment of freedom. Next slide. Soon after Congress enacted the seminal piece of civil rights legislation, we see Black women and men publicly challenging workplace grooming policies, barring their natural hairstyles as forms of not only racial discrimination, but also sexual discrimination, as well as an infringement upon their cultural expression. And we see this here with Deborah Brenwick, who in 1969 publicly declared that United Airlines placed her on a suspension and then ultimately terminated her because she refused to change her afro. And according to United Airlines, they said that her afro didn't comply with their short hair look policy. And I would argue that her hair actually does perfectly comply with this short hair policy, but nonetheless, she's terminated. And in 1976, the U.S. Court of Appeals for Seventh Circuit ruled that a Black woman who was denied a promotion because her supervisor stereotyped her as being unfit to represent the company policy, while donning an afro presented an actionable Title VII claim of race discrimination. Next slide. Then we see that even contemporarily, that Black women and men in our workplaces and other spaces are oftentimes discriminated against. We are harassed, we are losing employment opportunities, educational opportunities, housing opportunities, and so many more in the public sphere simply on the basis of our natural hairstyles, and oftentimes because of the negative associations with these natural hairstyles, namely being stigmatized as being unkempt, disheveled, unprofessional, aberrant, radical, militant, unruly, distracting, wrong, extreme, unusual, unattractive, and unacceptable. Next slide. And unfortunately, in light of, even though we are experiencing discrimination and harassment on the basis of our natural hairstyles, when you present these types of claims, race-based natural hair discrimination claims in federal court, we're often met without any kind of legal recourse. Really harkening back to 1981 and a very similar decision by a federal district court in New York in Rogers versus American Airlines, where the federal district court affirmed that if an employer discriminated against a Black worker for wearing an afro, that could amount to unlawful race discrimination and violation of Title VII's prohibitions against race discrimination. However, the court held that a workplace grooming policy that barred Ms. Rogers from wearing her cornrow braids did not violate federal civil rights protections against race discrimination. And so for 4 decades, federal courts have repeatedly adopted the ruling in Rogers versus American Airlines that basically declares that if an employer fires a Black woman because she wears an afro, this adverse employment action would constitute unlawful race discrimination because they are immutable characteristics of Blackness or African ancestry, based upon this idea that only Black people rock afros or are born with afros, which we know is not true, or that if you do wear an afro, then you must be Black, which we also know that's not true, right? And so in light of this, natural and protective hairstyles like braids, according to courts, are deemed mutable cultural characteristics that an employer therefore is free to regulate, since federal civil rights laws do not prohibit discrimination on the basis of culture. Next slide. Most recently, in EEOC versus Catastrophe Management Solutions, the 11th Circuit Court of Appeals fortified this, what I call a hair-splitting legal distinction, by declaring that Title VII protects African descendants from racial discrimination on the basis of afros, because afros are an immutable hair texture of African descendants, whereas an employer's rescission of a Black woman's employment offer because she refused to cut off her locks, and in this case, Chastity Jones refused to cut off her locks, did not violate Title VII because her locks were deemed a mutable cultural hairstyle. So next slide. Applying this misguided doctrine shaped by what I have argued is a biological notion of race, for over 40 years, federal courts have boldly declared that when an employer denies an African descendant a job because she adorns an afro, the employer engages in unlawful race discrimination. However, the moment you twist, you lock, or you braid that afro and suffer adverse treatment on those grounds, the employer's discrimination is deemed lawful. So what does that mean? Employers are then essentially free to demand that African descendant men and women alter, cover, or cut off their natural hairstyles as a condition of employment, oftentimes impose as a condition of employment that you straighten your hair. And employers are also free to discipline and harass and deprive Black workers promotions and related compensation for simply donning their hair as it naturally grows, unless it's an afro. Next slide. This hair splitting legal distinction has left countless African descendant women, men, and girls and boys without legal recourse when challenging the racial discrimination on the basis of their natural hairstyles and the resulting harms of this discrimination. Therefore, the need for legal reforms which redress racial discrimination in all of its manifestations. Next slide. Appreciating the significance of substantive, not symbolic legislation to redress this kind of legal inequality, before there was even a Crown Act, in 2013 and 2014, I lobbied those members of Congress, informing them of this hair-splitting legal distinction that was leaving countless individuals of African descent without legal recourse when they were challenging race-based natural hair discrimination. And in particular, in 2014, I mailed a letter to the entire female membership of the Congressional Black Caucus, chaired by then Congresswoman Marshall Fudge, as they were actively engaged in the reformation of the United States military's grooming policies that barred service women from wearing natural hairstyles, calling them unkempt and matted. In this letter, I explained that countless Black workers in the private sector lack federal civil rights protections against race-based natural hair discrimination, except for in that limited case of afros in light of this federal jurisprudence. Next slide. In this old school mailing, I also included my 2008 publication, Title VII, What's Hair and Other Race-Based Characteristics Got to Do with It, in which I proposed a definition of race that you can see here, which is now iterations of this definition of race are now being adopted in Crown Act's parallel civil rights legislation and endorsed by federal and administrative law judges. And in so doing, I recommended the revision of our federal civil rights laws to attend to not only race-based natural hair discrimination, but all manifestations of racial discrimination that were going unredressed under federal civil rights jurisprudence. And I went on to, as I mentioned before, to lobby to this effect. And as we know, next slide, for civil rights legislation to come to fruition, we all know that it takes not only a constellation of social, legal, and political stars to align, but many, more importantly, the dedicated advocacy and support of many. In the United States and other countries, natural hair discrimination has been a lawful basis for racial discrimination until more recently with the enactment of groundbreaking enforcement guidance from civil and human rights agencies, judicial decisions, and civil rights legislation commonly known as the C.R.O.W.N Acts, or Creating a Respectful and Open World or Workplace for Natural Hair Acts. And I have to say, it really should not have to take legislation to declare that our human right to wear our hair as it naturally grows. However, in the United States, civil rights legislation has been a really important tool to cure this unjustifiable gap in federal civil rights protections against race discrimination that our federal courts have created. So the civil rights legislation that we often hear about, known as being the C.R.O.W.N Act, parallel civil rights legislation, importantly provides a clarifying definition of race, and in some cases, race and national origin, which delineates that characteristics that are historically, commonly, or just simply associated with race animate unlawful racial discrimination. Some of this legislation also reflects the intersectionality and overlapping nature of experience for many African descendants. Wearing natural hairstyles like locks is a feature of our racial identity, our religious or ethnic identity, just as wearing a hijab is the expression of many Muslim women's religious personhood. Through this civil rights legislation, like many anti-discrimination laws are grounded, or though this civil rights legislation, like many anti-discrimination laws, are grounded in the experience of African descendants, this legislation, is important to note, protects all people from racial discrimination and fortifies a very central purpose of civil rights law by removing a common dilemma that individuals should never have to face, being forced to choose between the expression of their racial, ethnic, or religious identity and an employment or educational or housing opportunity or any other opportunities in the public sphere. Though the C.R.O.W.N Act makes clear that discrimination on the basis of natural hairstyles that African descendants commonly wear are associated with our cultural aesthetic constitutes unlawful race discrimination, the C.R.O.W.N Act and parallel civil rights legislation are equalizers and unifiers. This legislation does not render special treatment, but rather ensures equal treatment under the law for all who encounter racial discrimination. So fast forward, next slide. In 2019, we see the C.R.O.W.N Coalition, actually we can go back a little bit. We see in 2019, we see the C.R.O.W.N Coalition advancing civil rights legislation in California. California was the first to enact a C.R.O.W.N law. Actually, we can go back to 2 slides. No worries. In California, New York, this is the C.R.O.W.N Act of 2019 for California. I served as a legal expert and testified on its behalf. We see also New York and New Jersey passing these original C.R.O.W.N Acts, and in doing so, using not only my legal scholarship and advocacy, but also the scholarship and advocacy of other legal academics like Paulette Caldwell from NYU and Professor Angela Willick, who is the Dean at Boston University School of Law. As a legal expert, advisor, and co-drafter of now over 20 pieces of civil rights legislation in the United States, including California and the federal C.R.O.W.N Act, which had been passed twice by the United States House of Representatives. And it's important to know that one of those individuals who was extremely helpful is actually here. So Jelena Porter was extremely fundamental in making sure that the federal C.R.O.W.N Act was not only crafted, but also passed twice. And so it's been a tremendous privilege to work in partnership with individuals like Jelena, with legislators, grassroots organizers, civil and human rights agencies, and everyday citizens across the country to advance a history-making piece of civil rights legislation that combats the systemic deprivation of employment, loss of compensation, professional advancement, educational opportunities, and other infringements upon our dignity and freedom, such as the persistent policing and harassment Black people often experience when donning natural hairstyles like braids, locks, twists, and afros. So that being said, unbeknownst to many, this legislation now has been enacted in 19 states and over 40 municipalities, and in doing so, it intercepts centuries of lawful racial discrimination that African descendants have endured on the basis of our natural hair texture and hairstyles. And I'll go to just sort of some of the last slides here. Just in the interest of time. Oh, can you go back really quickly? Because I just wanted to make sure that also that we're not only talking about legislation, but it's also important to note that there's really some really important litigation that's going on in this space as well. That's really overturning some of these centuries of, or say decades of legal precedent that declares that natural hair discrimination is not race discrimination. And this is just one of those cases that the Legal Defense Fund has taken on behalf of DeAndre Arnold and Caden Bradford. And you might have heard about them. They're students in Texas. DeAndre Arnold was told that he would not be able to participate in his graduation unless he cut off his locks. His cousin likewise was unable to matriculate and engage in extracurricular activities. They both had to transfer to new schools because they were deemed in violation of their grooming policy that prohibited male students from wearing their hair or growing their hair that made it look like it had the propensity to touch their shoulders. Okay, so but importantly, I'm serving as a legal expert in this case, but importantly, for the first time in federal jurisprudence, to my knowledge, a federal court actually has declared that they have brought forth actionable claims of race discrimination in violation of our 14th Amendment, actionable claims of sex discrimination in violation of the 14th Amendment, and also an actionable claim of infringement upon their cultural expression in violation of our First Amendment. So there has been even more legal reforms other than the legislation. Additionally, there's been groundbreaking enforcement guidance, like for example, out of the New York City Commission on Human Rights. And then also just wanting to make everyone aware of this new litigation that really is quite important and may be proceeding through our judicial process. So next slide really quickly. And all of this really, for me, has resulted in what I call the hashtag Free the Hair mission. All of you have buttons or should be able to get a button. And this is really the culmination of over 15 years of legal scholarship and research and writing and publications, really trying to ensure that the systemic discrimination that African descendants around the world endure on the basis of our natural hairstyles comes to an end. That this no longer has to be not only a civil rights issue for the 21st century, but for the centuries to come. And so this is all a part of a broader body of work, next slide, that I call grooming codes discrimination, which really helps to embody the kinds of discrimination that we're experiencing on the basis of our grooming and appearance that I think are not only infringement upon our personhood, but really do implicate our civil rights protections against race discrimination, among other types of protected classifications under our civil rights laws. And so last slide. And so the Free the Hair movement, alongside the C.R.O.W.N Act movement and other types of movements that are really happening around the world as it relates to trying to bring about legal and policy reforms to combat race-based grooming codes discrimination, really to speak the words of American civil rights lawyer and pioneer Pauli Murray. She said that the business of oppression is not respecting one's personhood. And again, she said, the business of oppression is not respecting one's personhood. And so it is my hope that as we are continuing these conversations, as we're learning about one another's experiences and observing the differences, and I see the positive differences in who we are through the ways in which we may rock our hair or wear certain clothes, or the ways in which we're just navigating throughout society, that we are no longer engaging in the business of oppression by implementing and enforcing grooming policies and norms that both perpetuate a racialized hierarchy of acceptability, attractiveness, and professionalism, and dishonor one's unique personhood, culture, and identity.